So what's going on? Need another mask?
I guess.
Uh-huh. Or enjoy the personal freedom of having a mask. Any questions about anything? Yeah.
Are you in faculty senate?
Yeah, I'm an officer in the faculty senate.
How is that? What is that like?
With respect to what?
Any of it? I mean, I'm a part of student government, so
Yeah.
we have our senate,
Right.
and it's like sometimes a frenzy,
Yeah.
sometimes it's well structured, that sort of thing.
It's a pretty orderly body. So it meets as a whole monthly, and with occasional special sessions being called. The executive committee, which consists of the officers, so the president, the vice president, the secretary, the member at large, and all the chairs of the councils, the various councils of the Senate. That meets additionally monthly, so two monthly meetings plus special meetings and a lot of conferring among the officers as to what should be on the agenda for the various meetings. And it's the principal faculty advisory board to the administration, but it has only advisory powers. So they don't have to listen to us ever, and they usually don't. When I first got on Senate, it involved a lot of the administration coming to us and telling us the various things that we were going to be doing. But since then, there's been a lot more proactive work initiated by Senate itself, passing resolutions and whatnot. And it's been rather more willing to be resistant to what has to be understood to be extremely top-down actual management style of this university. What else can I say? Yeah, but yeah, what else do you want to know?
I mean, I haven't met a lot of professors that are on it or that like have been, I guess, talked about it. And I'm kind of
Yeah, I
curious
mean,
what type of professors, if there are any, like.
You know, frankly, when I got here, I'd been at several other universities before I came here, and I was pretty much immediately struck by the feeling that this is an unusually top-heavy, heavy-handed, administratively run institution. Faculty voice doesn't seem to count for much. All kinds of decisions about what, you know, that I would have thought would have been either in faculty, in the control of faculty, in their individual departments, or would at least be faculty voice would be important, just didn't seem to be. I served on the College of Arts and Sciences Faculty Council, both as just a member and then as the chair of that council, and again found, you know, basically what happens is your senior administrator or your administrative boss, the dean, or in the case of this Senate, the provost, comes and tells you, here's an initiative from on high that you are tasked with implementing. Whether you agree with the initiative or not, we don't care, but you know, your role will be facilitating administrative will at the level of faculty and curriculum and stuff like that. So a favorite phrase of the administration, in particular the provost, is faculty driven. right, initiatives, faculty-driven programs, et cetera, et cetera. And my view is that, by and large, they are faculty-driven in the sense in which a car might be chauffeur-driven, right? The chauffeur doesn't get to decide where the car is going. He just gets it where he's told to put it. And, but I noticed this very early in my time here at USF, and it irritated me, so I decided to get involved so that I could know a little bit more about the power structures that were, you know, opaque to me and yet making such a difference in the life of my colleagues and you know, my colleagues both in the general faculty and in particular in my department. And it's been a real education. But, you know, one of the main things I learned is it's an advisory body and we can say anything we want. But if they don't want to do it, they don't. We did this past year with respect to the budget process where they were going to make huge cuts. We did get involved in figuring out what was going on with that, whether it was justified, et cetera. We got regular meetings with the president of the university and the provost and the chief financial people. And they failed to persuade us that there was actually any real need to make cuts in that degree, or that they had engaged in anything like a transparent, rational process in apportioning the cuts. To the point where, well, let's see, it's no coincidence, I don't think, the chief operating officer resigned, and the president asked for an internal audit of the budget, which showed there was, in fact, no such need to make these cuts. And so we had a sort of unprecedented level of communication with, you know, serious back and forth with the administration. And the president announced, you know, he got rid of the chief operating officer and, you know, on the basis of this audit, basically overturned all the budget cuts. And then he left. I'm wondering whether there's some connection between his actually listening to faculty in a way that made a difference and his sort of evidently not being welcome to keep the third year of his term. But that's the cynic in me, which is pretty much all of me. So is that enough? Can I teach this class now? Okay.
I didn't mean to diverge.
It's okay, but obviously it's something I can get revved up about. But I can get revved up about this stuff too. See the whole slide on there. So, where are we? Somebody remind me. Okay.
The bad man, yeah.
So from the perspective of the bad man, anyway, there's nothing at all per se wrong with violating the law. Wrong and right and wrong don't really matter. What matters is the effects of my conduct, the consequences of my, you know, proposed conduct in terms of what a court might rule about what I have to do, pay a fine, go to jail, et cetera, et cetera. And that's really what Holmes identifies as the genuine content of the law, is the effect of those decisions. But he also does talk about the law being predictions about what those decisions are going to be. And there's a kind of a tension there. Which is it, Ollie? Is it the predictions made by the lawyers, or is it the actual decisions? And it's not really, he says things that indicate both of those results, but they're not the same thing. Okay. He says, he already identified a fallacy. It's the fallacy of confusing the law the way the bad man would see it, right? That's the law, and morality. So mistaking the notion of legal malice for some moral notion of malice involving intention. thinking that the wrong of breaking a contract, right, the legal violation, as it were, breaking a contract, is somehow a moral wrong. That's a fallacy, okay? There's another fallacy that keeps us from seeing what the law actually is. And this is a fallacy involving how the law develops. Oops, give me a second here. Okay. So how the law develops. Austin thinks of the law as the commands of the sovereign. Aquinas thinks of the law as the entailments and determinations of natural law by humans. Right? Or suppose you think of the law as sort of the voice of the zeitgeist, the spirit of the times, right? No matter how you think of it, though, we're still going to be interested as lawyers and as potential litigants, right? People who want to engage in business or other activities that could become subject to court proceedings, right? We still want to be interested, for the sake of prediction, in discovering some order or explanation or principle of growth in the law. How does it develop? And it's in connection with this that this second fallacy arises. And this is the fallacy of thinking that the only force at work in the development of law is something like logic. Logic is not the sole or even predominant, maybe, or maybe even a major force in the development of law. How law is going to go, now remember, he's identified the law with the decisions of the courts. So every law, every new law, or every new decision is essentially a matter of the development of the law. Right? Not just an application, but a new determination of law, a new development. Because the rights didn't exist until they were determined by the court. So the law develops with every decision. So how do decisions get made? That's going to be crucial to understanding the development of law. And it is a mistake to think that, that a judge's decision-making is a matter of some sort of mechanical application of rules to facts. Some sort of, derivation from axioms to theorems, with the result of the case being like a theorem derived from axioms. If that were true, it would be possible to determine that a given application of the law was absolutely correct. Just the way that you can determine whether a proof is valid. Okay? But that's not the case. And anyone, especially a judge who thinks that it is the case, and that they can persuade themselves that the way they've decided is absolutely right, is simply deluding themselves. And this is a dangerous delusion in a variety of ways. Look, judges make decisions like anybody else. They're subject to myriad influences. Okay? They are not just cold, calculating, mechanical, calculator. They're not calculators. Okay? And among the things that influence how judges decide is psychological quirks or just characteristics of the judge. Frank will go into greater detail about this. And their policy preferences. The problem is that if you convince yourself that that's not going on, it'll still go on, but badly. If you're going to be influenced by policy considerations in deciding cases, which will have, which decisions then become more of the fodder for future legal predictions, and so will have make a difference to people's further predictions and therefore their actions based on those predictions. If you're going to be making decisions on that basis, you should at least be consciously aware of what those influences are, and so that you can reflect about whether your policy preferences that are operating, subconsciously or whatever, are in fact good considerations. If you're going to be implementing policy in deciding cases, you should know what the policy is so you can be reflective about it and, think, well, is this the way I really think things should be, so that it can be open to scrutiny. So there's a whole lot of the sort of apparatus, the official apparatus of judicial practice that's designed, more or less, to cover up the fact that judges are influenced by things like their policy preferences. So there's the idea that dissenting opinions, when a judge in a multi-judge panel, Supreme Court or appellate courts or whatever, writes a dissenting opinion saying the majority got this case wrong. There's a temptation to think, well, if the majority got it right, then the dissenting opinion must just involve something like a calculating error. Okay? And the whole style of writing judicial opinions is designed to make it look like the result was compelled by the facts and the law. That is, look, I was a lawyer. I practiced law. I wrote many, many memoranda in the course of that as to what is the law on this point. Okay? And I'm here to tell you, if it was even slightly an interesting question, there was precedents that went one way and precedents that went the other way, and you just pick and choose your precedents or your reading of the law, and you will get the result that you want. Any result in any even mildly interesting case, can be, support for that result can be found in the materials available to the lawyer or the judge. So pretty much for any even mildly interesting case, you can argue that the law determines that the plaintiff should win or the law determines that the defendant should win. But we act like that's not true. And it's an act. It's an act that's in the service of this idea of judges don't make law. And that is in turn in service of the idea that that lawmaking power is in the hands of the legislature. And that's in service of the idea that the real power resides with the people. So, there's a, yes, please.
I just have a question, like, when we're talking about this subject, how, if a judge has like a bigoted viewpoint,
Yeah.
How are they held accountable? Because it doesn't seem like they would be.
Well, okay, we're going to be talking about this basic issue, not the bigoted judge, but just the extent to which there is discretion, what we might call discretion. We'll talk more about discretion in a more specific way when we read Ronald Dworkin. But the extent to which the judge's decision always is underdetermined by the law and the facts, right? So that the decision could have gone either way, and what things influence judges to decide one way rather than another, given that they could have decided either way. That's going to be an issue that's going to be with us throughout most of the term. I mean, almost at every turn through most of the term. That said, judges do try to justify their opinions. It's not as though there are arguments that will not pass muster. Okay, it's not as though absolutely anything goes. So there is kind of boundaries as to what a judge can get away with. But within those boundaries, it could be that there's just racial animus that played a role. But for the racial animus, the judge would have decided the other way. Or but for the misogyny, the judge would have decided the other way. Or but for the judge's disdain for poor people, it would have gone the other way. So, as Frank will argue, in connection with the paradox of precedent, is he'll argue, look, if you really wanted to know what the precedent of a case is, or what the significance of a case is in terms of its being a precedent, you have to know the actual psychological process by means of which the judge made the decision. But actual psychology, that's basically unknowable. The full-on actual process that went through their mind, conscious or otherwise, that yielded the result. That's not something we can know. And moreover, it's certainly not something that's reflected in the judicial opinion that's handed down, which is what the idea of the precedent of the case typically is drawn from. So I'm talking around your question. The answer is there is no way. Right? We don't know whether Scalia issued the opinions he did because deep down he's a Catholic and not because he's a lawyer. We don't know. But there's a lot of rhetorical pretend that says, oh, that's not a serious question. Of course, it's just the law that's determining his. How could there be, right? How could the court be as ideological as it is if it was all just a matter of, well, we're just applying the law? Okay. So judicial opinions are generally written so as to make it seem that the law determines the outcome all on its own. Okay. But Holmes says no concrete statement, by which he means a substantive statement that, right, decides a case in a given way, is self-evident. So basically he's saying that this conclusion follows from the law inexorably, right? That's a concrete statement, and there is no such, actually, yeah, that's a concrete statement, right? As opposed to an actual deductive entailment. A deductive entailment is not a concrete statement in the sense of it doesn't add anything. To say that some conclusion is entailed in the premises is to say that it doesn't add anything to the premises. It's already there. He's saying no judicial opinion is like that. So the claim that the conclusion follows from the law is a concrete statement, not a statement of an entailment of a deductive sort, right? And it's only deductive entailments that are self-evident. Every judicial, right, opinion that pretends that it's a matter of simply applying the facts to the law in a deductive way, the law to the facts in a deductive way to yield an entailed conclusion, every one of those is a concrete statement which is not self-evident, masquerading as a self-evident statement. Okay. Judges do make decisions based on policy considerations. He gives examples of developments in the law like this. So an example, privileging statements made against servants, right? Even if they are false, because that encourages free flow of information. So the idea is we're not going to, so like if somebody writes a letter of recommendation, something like that, that says something negative about somebody, we're going to consider that privileged in some way because if we allow actions against people for certain kinds of communications, that will restrict the free flow of information. So we'll regard these as confidential. The prospective employer or the prospective employee is not allowed to see the reference letter, because if they are allowed to see the reference letters, then people will not be candid in giving their references. So this is a matter that is kind of a big deal around here if we ever get to hire faculty or in the tenure process. Our letters that are written in support of people's tenure and promotion cases in the faculty, are those accessible to the tenure and promotion candidate? Well, one argument says if they are, then no one is ever going to tell the truth. They're always going to say nice things, right? But if they're not, then how does the candidate know whether they've been treated unfairly in the process? So that's just a policy decision. But judges make decisions about these things that end up being binding. They do it on policy grounds. He points out that there can be contrary trends in public policy development. Well, one thing that was big around the time that Holmes was writing was the development of strict liability in tort law. So tort law is a tort is when someone damages you in a non-criminal but actionable way, right? You sue them for having whatever damaged your business or done something that engaged in unfair trade practice or something like that, or just stepping on your toe negligently, right? You get hurt on the workplace in the course of doing your job. You sue your employer. Well, under what conditions should they be liable? Okay, should we hold them to a standard of negligence? So that only if they're negligent should they pay? Right? Well, at the time that Holmes was writing, there was a lot of development in the idea that, well, no, actually, we're going to have strict liability for industrial accidents. But why? We don't have strict liability for ordinary accidents, right? You're not liable for a harm you do to somebody in the ordinary course of your day unless you behaved in a way that wasn't appropriately cautious. Okay, but what about, so big policy debate. In industrial enterprises, they're so important because of what they produce, but they're also intrinsically dangerous. So we want to incentivize people to work in such things and to engage in such enterprises, right? But we don't want to make the costs of doing it, or rather, we don't want people to have to prove that there was actual negligence, because then no one's going to want to do that work, right? So how are we going to think about this? Well, as a matter of public policy, the idea was, let's make businesses strictly liable so that they can just pass the costs of the harms that will inevitably occur in such business, in such enterprises, pass the costs along to the consumers, and that way the consumers are effectively insuring the workers. So that's a public policy decision, and that kind of liability system was developed through the courts. How about and that actually was influenced by the fact that juries would regularly find defendants in industrial accident suits liable in cases where they didn't seem to have been negligent, because the jurors thought, I don't care if they're negligent, they're the big bosses with the bucks, and this poor schlup, lost a foot, so he should get compensated, because they're the ones with the financial resources to make that person whole, right? And they're the ones with control over how much care they take, and they can pass the costs on. So, juries, in deciding negligence cases a certain way and being, having what appear to be overly harsh determinations of whether a business behaved negligently in order that they might get a judgment for the plaintiff, they indicated that as a policy matter, people think businesses ought to pay for the harms that occur in the course of their reaping huge profits off of the backs of workers who are at risk. So judges were responsive to that. Okay. So Holmes says, look, the duty to weigh public interest and social progress in judicial decisions is inevitable, and judges should simply be open and candid about it. If they recognize that that's what they're doing, they might recognize that their tendencies along these lines, like, for example, the tendency to treat freedom of contract as some right enshrined in law, is in fact a commitment to a policy preference in a hotly debated matter of public policy. So another thing that was going on around that time is that with the rise of industrial labor, there was a lot of, sweatshop child labor, and employers demanding that workers work 80-hour weeks and stuff like that. So the people would, laws would be passed to restrict child labor, restrict work hours, et cetera, et cetera. The employers would sue to have those laws struck down on the grounds of freedom of contract. Okay? That person entered into a contract which said they would work at 80 hours a week. Okay? That kind of thing. Judges who, there was this law, freedom of contract, right? Judges who stick blindly to that idea and think that they have no basis making any decision on in terms of public policy might be entirely blind to the fact that in sticking to that idea, they're in fact taking a stand on a hotly debated matter of public policy. So the point is, treating law as if it is some set of rules and principles that mechanically determine the outcome of cases isn't neutral with respect to public policy. you're taking a stand on what the public policy should be one way or the other. And you might say, well, let the legislature change it. Legislatures are terrible at making law. In any event, right, it's simply not the case that, on Holmes's view, that judges ever, in fact, are just plain applying the law the way it is. So they're going to be making decisions based on public policy. You might as well face up to that. And then what you'll do is you'll justify your opinion in terms of its being a good public policy, rather than in terms of its being the law of the land, right? And then if the legislature doesn't like what you've done, then it can overrule you. But it can't overrule you if what you're, especially in cases of constitutional weight, it can't overrule you if what you've said is the Constitution dictates this result. Yeah.
So on Holmes' view, the court's invocation of the political questions doctrine would just they should, saying that is taking a stance on the political question.
Well, I don't think he would say never do that, but he would say, don't pretend that don't pretend that the line between a political question and a question of law is a bright one. Some things fall way on one side and others way on the other. But there's a hell of a lot of in-between. And in that in-between area, you're going to be making political or policy decisions without being aware of it. Right? So, and if you're not aware that that's what you're doing, you're going to do it badly. I think that's the view. I mean, really, the consequence of what he's saying is that there's actually almost nothing that's not a political question in some sense. And if judges if judges were strictly, right, able to resist the temptation to make any policy decisions, they'd never make any decisions. Everything would be a political question. Everything would fall outside their jurisprudence, the scope of their legitimate jurisprudence. But that's crazy. That can't be. I mean, and so, just let's stop playing pretend here. So as I said, this was a highly influential legal movement or legal movement in jurisprudence in the first half of the 20th century. The second half of the 20th century saw a lot of resistance to this. And what's happened since then, in my opinion, is basically we have a completely polarized, not so much in, amongst philosophers of law, but in the public imagination, we have a completely polarized conception of the judicial function and what actually goes on and how judges ought to think about what they do. And, you've got the people who are more or less like the realists. And in fact, in the academy, a form of legal realism has reemerged very strongly in the critical legal studies world, where the idea is, the law is a tool of power. And we'll talk about that stuff later on. But, it just sees law in terms of power terms, or in power terms, and as a way of, dominant groups reinforcing and consolidating and augmenting their power, not as the impartial hands of justice and the blind eye of the law. No, it's, right. Versus the view that says, you know, right, no, judges just can and should apply the law as written and leave all the political questions to the legislative branch and not think of themselves as having any, you know, law-making function. And it's pretty much aligned left versus right, yeah, those two perspectives. Yeah.
Kind of makes sense. Privilege has a big all works. Like all the time, certain people get away with stuff. Law doesn't kind of work that it does for the rich. So if someone and they're poor, they don't have money to pay it. So let's say people avoiding it, eventually that can get them into a situation where like. But for someone who's like rich, a parking ticket isn't really like consequence. It's kind of just like they can keep paying the ticket. Like parking laws wouldn't really be something that they're constrained by because money isn't something they're constrained by. So they could like live their whole lives parking wherever, doing whatever they want, and they would never face any kind of consequence from the law. Whereas someone who's poor, like
Yeah.
those laws like kind of control their lives, so they would eventually have to face the law. Like someone.
Yes, I agree with what you're saying in its general shape, and we'll talk a bunch about that in more in more specific contexts, like in terms of patriarchy, in terms of punishment, theories of punishment. We'll be talking quite soon about the Law and Economics School, which sees law primarily as a tool of economic efficiency. And one of the things that underwrites that idea is a kind of economic theory according to which a dollar is a dollar is a dollar. By which I mean, I'll put it in terms of the point you made. Yeah, rich dude can afford to park wherever they want and just pay the fines. Poor person can't. Right? Well, what does that mean? It means that the rich dude's $5 are worth way less, or $50 or $100 or per dollar. The rich person's dollars are worth way less to them than the poor person's dollars are. Right? The poor person's dollars pay their rent and their food. The rich person's dollars pay their, yacht polishing bill. And that's just not as important to a human being as their rent and food. So per dollar, the rich person's dollars are worth less. That's why they can throw them at parking fines. Okay, now that sort of makes sense, right? The basic law and economics view, the economic theory underlying that says, no, that's not true at all. There is no more value to the poor person's next $5 than there is to the fabulously wealthy person's next $5. But yeah, law, and especially according to the critical legal studies, people and of that ilk, law enshrines privilege. Law is a way of maintaining privilege. I mean, just think of the history of even post-Jim Crow laws about redlining. Think about the laws that, according to which school boards are funded by local taxation. I mean, it's not far to find where laws are used as a tool of enshrining privilege. Which, right, really makes it seem like there's a big difference between the law as it is and the law as it should be, which makes it seem as though we ought to be paying more attention to law as it should be, right, in the interest of justice and equity, and pay less attention to the rhetoric according to which we shouldn't be, we should just let legislators make laws and have judges simply apply them. Because the judges are making law, whether you like it or not, and if they're going to be doing that, I mean, considering the way that our legislators are actually selected, right? Wouldn't you really rather have somebody who's not democratically responsible or responsive, but is actually just responsive to justice in the case, making the laws? That's not democratic. Yes, well, the United States Senate isn't democratic either. Gerrymandering isn't democratic either. Campaign finance laws aren't democratic either. But that's, don't get me upset like that. I'm going to get in trouble. All right, let's move on, talk about Jerome Frank. It's an excerpt from Law and the Modern Mind. The nominal topic here, which we've been, talking about, is, do judges have the right and power to make law? He contrasts the typical and dominant view, which is that law pre-exists judges' decisions and forms the determining basis of them. Judges merely apply the law as it already exists and do not make it. Judicial opinions on this view are simply evidence of what the law already is. Moreover, judges who attempt to make law, who actually do let public policy considerations influence their decision-making, act unconstitutionally, usurping the legislative function. Then he characterizes what he calls the minority view, which is obviously correct. Judges make law. I'm missing some quotation marks. Should be quotation marks there. Okay. Given that the contrary and minority view is obviously correct, Frank asks what the explanation for the tenacity of the tenacious persistence of the old view is. And he says, it's the illusion or myth that law can be completely predictable. This illusion, the attractiveness of this illusion, is backed by what he calls the childish desire to have a fixed, chance-free universe. And that strikes me as interesting. He's saying, right, this is just infantile, right? The world isn't predictable. There are stochastic processes. Things aren't determined in advance. The world is a chancy place. Can't predict everything. And I'm not sure that's the best way to analyze the tenacity of the traditional view. It seems to me that there's at least a couple of possible other sources of the view. One is not the illusory belief that the world can be completely predictable, but it's the reasonable desire that there should be as much certainty as possible so that you can plan how to run your life. And the idea would be that if we act as though the law ideally is predictable and judges should just apply it as it is and justify their opinions and decisions on the basis of the law, right? Do their best to show how the opinion was justified by the law, that will maximize the actual amount of predictability. And that is good. It is good that people in general should be able to consult the law in a way that, and Holmes realized this, right? The effort in writing statutes and the common law, etc., is designed to make things as predictable as possible. Okay? And that's not a childish desire. That's not a desire for a chance-free universe. It's a desire for, right, a more manageable universe. Now, that's not the same thing as saying it justifies a belief that, in fact, judges do not make law. It's rather justifying a regulative ideal that judges should try to avoid making law. And that's a reasonable ideal on grounds of maximal predictability. And another reason that you can cite in favor of this the persistence of the view that judges don't make law, but again only as sort of promoting an ideal, try not to make law, is the ideology of democracy, right? This idea that legislative power is delegated to our representatives from the people, so it's ultimately the people's power, and that judges who are not electorally accountable, right, shouldn't be the ones to exercise it. Again, it's not that the claim would need to be, and so they never do. The claim would need to be, and so they should try not to. Now, that's another basis, and that's not just a silly, childish, it's childish in a way, but not the same way he's talking about. It's childish insofar as it covers over the actual reality of the way the democratic process works. But the way the democratic process works, but right, supposing our democracy functioned much better as a means of getting the law as passed to represent something like the will of the people and getting the elected officials elected actually in a fair way that wasn't queered by money and all that sort of thing. If it actually did that, then you might say, well, we've got a genuine functioning democracy, legitimated by its being, the government being legitimated by its actually being both representative of and responsive to the will of the people. So then that would be a situation you'd say, and so judges who are not elected should try not to make law. That wouldn't be childish at all. So again, I just think the tenacity of the old view is not simply to be explained by childish desire for perfect predictability. But both of the kinds of justifications I gave, again, I want to say, they're not backing up the old view, right, the traditional view, as literally true. They're backing it up as saying that's how we ought to think about the role of judges, so that we can maximize predictability and minimize judicial usurpation of legitimate legislative authority. That's different from saying, and so therefore the law does in fact exist in a determining way prior to judges' decisions. The way of saying that's how they should think about it. Yeah.
So there are like different reasonable schools of thought once you see that judges make law. They don't merely.
Well, there, yeah. Yeah, there are different ways of thinking about, look, I mean, one way of thinking about it is to say, if they're going to make law, they should make law on the explicit basis of public policy, blah, blah, blah. Another way of saying they should not do that because that usurps democratic, prerogative, legislative prerogative, et cetera, et cetera. I mean, there's varying things, there are all kinds of different things you can say about how we ought to think of the way judges should think of their jobs, even if we acknowledge, yeah, they're going to be making law. You can encourage it, you can discourage it, and you can encourage and discourage it on a variety of grounds. But the traditional view denies it, or says that when they do it, they're not functioning as judges. They're not doing, what they should do. And that's inconsistent with the view that necessarily this is going to happen. All right. But in line with the idea that there should be perfect predictability, there's the idea that, well, the law should be regarded as eternal, unchanging. And of course, the legislature changes the law all the time. But now Frank makes another move. He says, but look, the way legislators change laws is fundamentally different from the way that judges in making law change law. And the difference is this. When a legislature changes a law, right, it operates only prospectively. So the actions that that law governs are after the change in the law. And so you can, right, it only governs actions such that the agents of those actions can be already aware of the law, of the new law. But when a judge makes a law, as it were, when they make law in deciding cases, they're deciding what the law was and applying that decision retroactively to parties whose actions have already occurred before that law was made. So they can't have predicted what a judge was going to do at the time. They can't have relied on a knowledge of what the law was if the law didn't exist yet. Unlike the case of legislative law changes, he thinks, in which, well, they only govern actions in the future. So, right, people can, predict, can make their decisions based on what the law is. Now, that seems to me not particularly compelling. First, there are plenty of legislative changes which, while they don't apply retroactively, alter the circumstances on which people might have been relying in long-term projects. So, for example, if you change in the tax code can make a certain kind of investment less promising than it had been when you made it last year. Passage of a labor law, say a hike in the minimum wage, or a requirement to provide health insurance for employees, can make it the case that a person is unable any longer profitably to conduct a business that they've already invested in heavily. So right, while the law doesn't apply to the past, it can affect, as it were, a change in the law can affect dramatically the, um, the viability of projects that were made, or commitments that were made on the basis of prior decisions, decisions that were made before the law came into being. So, yeah, if the real reason you should always leave it to the legislature is so that there's no retroactive effect of changes of law, right? That, or rather, if it had to do only with the predictability point, then legislative changes to law are extremely costly in terms of predictability too, is my point. All right. In any event, if judges, Frank says, make the law in determining, in the course of deciding cases, the myth of predictability is exploded altogether, he says. And I've already sort of criticized this. Because it implies that the law governing the case at hand, judges are making law, doesn't even exist until the judge deciding the case makes it. So there is no law governing the case prior to when the judge makes the decision. And again, I think this is overstating the case. The fact that the law doesn't exist until the judge makes it doesn't mean that it can't be predicted, even with certainty, what law will govern the case. That's just to say, make the kind of point I was making last time about how, right, this right, background of also, you just know that if you shoot someone in broad daylight for no reason in front of witnesses, you're going to go to jail for murder. That's not, right, that's not, unless you're Donald Trump on Fifth Avenue or whatever he said. But you just know that. That's what the law is going to be. Okay? You can predict that with an enormous amount of certainty. Even if, strictly speaking, right, your rights weren't determined until the judge actually sentenced you. Right, in order to make it the case that the law isn't predictable, right, it's not enough to say that the law doesn't exist until the judge decides. You also have to say that what the judge decides is also entirely unpredictable. And that's not true. It's often true, and in hard cases, it's more or less always true. But with respect to very, very, very many cases in which what we want to know is what's the law here, it is entirely predictable what the judge would decide if it ever came before them, and for that reason, it never gets to them. All right. All right. So, legal realism. So, for Frank, the idea of legal realism is best brought out in a way that's a little bit like the bad man view from Holmes. It's brought out best in terms of what it means for the average person consulting their lawyer. What does the law, what's the law mean to the average person consulting their lawyer? And so he goes into this description of this case involving the exclusionary taxi contract with the railroad station. It's a lovely example. So what's the story? A company has a contract with a railroad station. People who own a railroad station or a railroad company, something like that, have a contract with a taxi cab company. which gives the taxi cab company the exclusive right to solicit business on the property of the railroad. Okay, but some other taxi company keeps trying to get business there, right? So the taxi cab company, the first one that has that contract with the railroad, soon goes to the lawyer and says, what can I do here? They're violating my contract and it's hurting my business. They're competing with me when I'm supposed to have exclusive right to this, right, on the basis of my contract with the railroad. And the judge, or the lawyer says, well, that's an interesting question. The law here in the jurisdiction in which you're incorporated is pretty clear that such contracts won't be enforced. So you would lose. But that's not the end of the matter, because you could incorporate in the state next door, and there, right, you can incorporate in the state next door, and that will give you federal jurisdiction. And a federal court, as opposed to a state court right here, is more likely to go with the majority rule. That is to say, more states enforce these kind of contracts than don't. Okay, but this state doesn't enforce them. So what you need is to reincorporate over there, and then maybe the federal court will apply the other rule, or maybe it will say, no, you just incorporate it over here to avoid the consequences of the law in your own jurisdiction. We don't like that, so we'll either deny jurisdiction or we'll apply the law of, what is it, Kentucky or whatever, et cetera, et cetera. And then so they go and they win, but then there's an appeal, and they lose on appeal, and then it goes to the Supreme Court. And the point is that such a situation as possible gives the lie to the idea that at any stage, the law governing the case is unclear and undetermined until the next decision has been made. Or as of any single stage, the only thing that you can say that the law is what the court had just decided, which the next court up the appeal process might not decide. And then when you run out of appeals, you're at the Supreme Court says, boom, and you have no more appeals. That tells you what the law of that case was. Or if you run out of money, so you can't appeal again, then where you ran out of money, that decision, the last decision, tells you what the law governing your case was. But you can't predict any of them with certainty, and it ain't over until you've run out of appeals money or courts to go to. Yeah. Well, again, I want to say no to that, because I think it overlooks the majority of cases, in the vast majority of cases, in which it's so clear what the law is, it never goes to contest. Okay? It's only when a client wants to go to, when a client thinks that the law is unclear enough that they better go get some advice. And when the advice they get is, yeah, well, it's unclear what will be decided there. It's unclear how to advise you. I could either tell you, if it's real clear, the lawyer says, no, you can't do that. Well, you'll get sued and you'll lose. Right? But there's a lot of cases in which it isn't clear. And those are the ones that get all the attention. Like I said, when I was writing legal memos, pretty much didn't matter what the client was looking for me to find an argument for in the law. I could probably find it. Okay? But they wouldn't be asking if it were something really, really obvious. Nobody goes to their lawyer and says, hey, look, can I buy a lot of stock in a certain company when I sit on the board of directors of and have inside information that that company is going to be, whatever, has just discovered a cure for cancer or something like that? No, the answer is no, you can't, and no one would think to go and ask, right? But there's a lot of cases where it's ambiguous, where you just don't know. And that's where judges actually end up having to write opinions. If a case isn't one in which it could have gone either way, there's usually, it never gets to the point of there being a judicial opinion written about it. Okay. So according to Frank, I'll just make a couple more points and then we'll quit a couple minutes early today because I don't want to get onto a whole next big topic with only a few minutes to go. The lesson be drawn from this taxi cab company case. The law isn't fixed until the final disposition. And when it is fixed, it only covers that particular case. It doesn't determine the law for future cases. So this is a statement, and he'll talk more about it later in the piece. It's a statement against the idea of judicial precedence, against the idea of stare decisis. Let it stand as decided. Right? The idea is, well, the particular facts of a case have never been litigated before. And so there is no law governing them. And so right, the previous cases are always distinguishable one way or another from the present case. And so the law from the previous case never actually really determines the outcome of a future case. Again, I think that's probably a little bit overstated, but it's often enough true. So there are two senses of law here. What was decided in a particular case as it pertains to that case? The decision here for these parties. And that's it, just for these parties about this, okay? But also, right, the understanding of what the law is that is responsive to the question that the client asks the attorney when they say, what's the law of so-and-so, which is actually a prediction of what the decision will be in that case. When I ask you, what's the law on so-and-so given these facts, what I'm asking you to do as a lawyer is tell me your prediction of what the decision will be. That's one sense of what the law is. It's your prediction. It's the sense in which it's an answer to the question, what is the law? Okay? But the other sense of law is just what the judge decided in the case. Okay. We'll pick up there next time and move on to our next topic, which I don't remember what it is. Where do we go next? It might be law and economics. Sorry? Part?
Yeah.
Oh, great. Part's my favorite. Good. Any questions from the... Any questions from the teams, folks? All right. I think I might have been a little scattered today. I was thrown by all the good questions that I wanted to talk about more than I wanted to talk about Frank. All right. See you next time.